welcome to the Deep Dive, your shortcut to being truly well-informed without all that information overload. Today, we're diving deep into something really fundamental: misrepresentation in contracts. Think about it. You're making a big decision, right? Maybe buying a car, signing a lease, even starting a business. You rely on what the other person tells you. But, well, what happens if what they said wasn't quite true? Our mission today is to unpack what misrepresentation actually means, legally speaking, why it matters so much, and importantly, what you can do about it. You might think you know what a lie is, but in contract law, it gets surprisingly nuanced. And those little details, they can make all the difference.
That's exactly right. It's so critical because contracts underpin so many interactions. And understanding misrepresentation, well, it's really about ensuring fairness. It's about protecting yourself if you've been misled. We'll look at, the specific things you need to prove, the different types, and crucially, the remedies, what's available to you. So what does this all mean for you the next time you're about to sign something? Let's explore.
Okay, let's kick things off with the basics. At its heart, what is a misrepresentation?
Right. So fundamentally, it's a false statement of fact made by one party to another. And it's not usually a term in the contract itself. But here's the kicker. It has to be something that induces the other party, that's you, to actually enter into the contract.
So it's the thing that convinces you to sign.
Pretty much, yes. It played a real part in your decision. And the effect isn't automatic voiding of the contract.
Okay, so it doesn't just cancel the whole thing.
No, it makes it voidable. And that's a really important distinction.
Avoidable. What does that mean practically?
It means the innocent party, the one who was misled, gets a choice. You can choose to set aside the contract. That's called rescission.
Rescission, right.
Or you can claim damages, financial compensation, sometimes both. It gives you a path to fix the situation rather than just blowing up the whole deal instantly.
Okay, so it's about a false statement of fact. That sounds simple, but I bet it's not always clear-cut. What actually counts as a statement of fact?
You're right, it can get blurry. We need to separate it from, say, just someone's opinion.
Or like sales hype.
Exactly, or statements about the future, or even statements about what the law is.
So opinions generally don't count?
Generally, no. A false statement of opinion usually isn't a misrepresentation of fact. Think of Bissett v. Wilkinson. A farmer gave an opinion about how many sheep land could carry.
Okay.
But both sides knew he hadn't actually farmed sheep there, so it was treated as just his honest opinion, even though it was wrong.
But I feel like sometimes an opinion can cross the line, can it?
It absolutely can. If the person giving the opinion is, in a much better position to know the real facts.
Like an expert.
Sort of, yes, or just someone with inside knowledge. And if they couldn't reasonably have held that opinion based on the facts they did know, then it can be treated as a statement of fact. Think of Smith v. Land and House Property Corps. The seller called a tenant most desirable. But in fact, the tenant was bankrupt. The court said, look, describing him that way implies, facts that justify it. It wasn't just an opinion in that context.
Got it. And what about those really vague advertising claims? Like, best coffee in town.
Yeah. Those are usually seen as mere puffs. Vague sales talk kind of statements, like in Dimmick v. Hallett, describing land as just fertile and improvable. Generally, they have no legal weight. A reasonable person wouldn't take them as literal, factual statements.
Okay, makes sense. But what if someone tells you what they plan to do in the future? Or what they will do, and then they don't? Is that a misrepresentation?
Usually not, no. Not unless that promise about the future is actually written into the contract as a specific term.
But there must be exceptions.
There are, and it's a crucial one. If someone states their future intention, but at the very moment they say it, they know they won't carry it out.
So they're lying about their current intention.
Precisely. And if that false statement about their intention induced you into the contract, then they'll be liable. Edgington v. Fitzmaurice is the classic case. Directors said they were raising money for one thing, but secretly intended it for another.
Okay.
And Esso Petroleum v. Martin is interesting, too. An Esso rep gave a forecast for petrol sales. Because Esso had special expertise, that forecast was treated like a statement of fact, not just a guess. When it turned out to be wildly wrong due to their faulty analysis, it was actionable.
So expertise matters there. What about statements about the law? Surely you can't misrepresent the law. Everyone's supposed to know it, right?
That's the general starting point, yes. Ignorantia juris non excusat. Ignorance of the law is no excuse. But honestly, the line between a statement of fact and law can be surprisingly tricky sometimes. Some cases show it's not always a clear distinction, especially with complex regulations.
Okay, this brings us to something lots of people wonder about. Silence. What if someone just doesn't say anything about a problem? Is keeping quiet a misrepresentation?
Generally, no. The old rule is caveat emptor buyer beware.
Buyer beware.
Yeah. If you're mistaken about something, the other party usually doesn't have a duty to step in and correct you. Smith v. Hughes is a good example. The buyer wanted old oats. The seller knew he was selling new oats, but didn't say anything. The buyer could have checked.
But surely there are times when you do have to speak up.
Absolutely. There are really important exceptions where silence does become a misrepresentation. 3 main ones.
Okay, what are they?
First, half-truths. You can't tell just part of the story if it gives a misleading impression.
So leaving out crucial bits.
Exactly. Like in Nottingham Brick and Tile Covey Butler. Someone said they weren't aware of any restrictions on land use, but failed to mention their lawyer hadn't actually checked the documents. That omission made the statement misleading.
Sneaky. Okay, what's the second one?
Second, statements that become false. Imagine someone tells you something that's true at the time, but then, before the contract is actually signed, circumstances change, and that statement is no longer true. They have a duty to tell you about the change. With V. O'Flanagan is the case here. A doctor selling his practice stated its income, which was true then, but by the time the sale went through, the income had plummeted because he'd been ill. He should have disclosed that.
Makes sense. You have to update them. And the third?
Third, contracts of utmost good faith. These are special contracts, uberi mai fide.
Like insurance.
Insurance is the classic example, yes. You have a duty to disclose all material facts, everything relevant to the risk. Lambert v. Cooperative Insurance Society showed this with undisclosed evictions. It also applies in family settlements, and crucially, where there's a fiduciary relationship like between a solicitor and client, there's an inherent duty of disclosure because of the trust involved.
And it's not just words, is it? Can actions count?
Definitely. Actions can absolutely imply a statement. Gordon v. Celico Ltd. painting over dry rot. That action was held to be a fraudulent misrepresentation. It was actively concealing a defect. And in St. Marylebone Property v. Payne, just putting misleading arrows on a photo to show wrong land boundaries that was considered a statement of fact. It's about the overall message conveyed.
Okay, so we've got what counts as a false statement, but that's not enough, right? You said it has to induce you.
Exactly. It has to have actually persuaded you, the representee, to enter the contract.
Yeah.
2 key elements here, materiality and reliance.
Materiality and reliance. Let's break those down. Materiality first.
Materiality means the statement must be something that a reasonable person would likely consider important in deciding whether to make the contract.
So it has to be significant.
Yes. But it's interesting how the law approaches this. Use prime properties v. ad hill properties helps here. If the statement would induce a reasonable person, the court basically assumes it induced you.
Okay.
The burden then shifts to the person who made the statement to prove it didn't induce you. But if it's something minor, something that wouldn't normally induce a reasonable person, then the burden is on you to prove that, for whatever reason, it did induce you.
Right. And then there's reliance.
Yeah.
That sounds more straightforward. You actually had to rely on it.
Spot on. You must have actually relied on the misrepresentation if you didn't even know about it. Like the buyer in Horsfall v. Thomas who bought a gun without examining it couldn't complain about a hidden defect. Well, you can't have relied on it.
Makes sense.
Same applies if you didn't trust their statement and did your own checks instead. Like in Atwood v. Small, the buyers got their own agents to inspect a mine. They relied on their agent's report, not the seller's claims. So no reliance on the seller's misrepresentation.
But what if you could have checked but didn't? Like they offered you the documents, but you just took their word for it.
That's a great question. And Redgrave v. Heard is the key case. A solicitor misrepresented his business income. He gave the buyer papers that would have revealed the truth, but the buyer didn't really look through them properly.
So the buyer messed up.
The court said no. The misrepresentation still induced the contract. Just because you had the chance to discover the truth doesn't mean the other person gets off the hook for misleading you. You're entitled to take them at their word, generally.
That's really important.
And remember, Edgington v. Fitzmaurice, again, the misrepresentation doesn't have to be the only reason you signed. It just needs to be one of the reasons, a contributing factor.
Okay, so once we've established there was an actionable misrepresentation, false statement, factual, induced, it gets put into categories, right? 3 types.
That's right. Fraudulent, negligent, or wholly innocent.
And why does that matter? Why bother splitting hairs?
It matters hugely because the type dictates the remedies, what you can get out of it, and how easy it is to prove. It's crucial for the innocent party.
Right. Let's start with the big one. Fraudulent misrepresentation. Sounds serious.
It is. It's the most serious. Lord Herschel in Derry v. Peake laid it out. It's a false statement made knowingly or without belief in its truth or recklessly careless whether it's true or false.
So it's about their state of mind, deliberate lying or recklessness.
Exactly. The key is dishonesty. If someone honestly believes their statement is true, even if they're wrong, it's not fraudulent. Proving fraud falls on the person claiming it, and, well, proving someone's inner state of mind can be tough.
And if you can prove fraud, what are the remedies?
2 main ones. Rescission, getting out of the contract, we'll talk more about that, and damages in the tort of deceit.
Tort of deceit.
Yeah, it's a separate legal claim for the harm caused by the fraud itself. And the damages here are quite broad. You can recover for all direct loss resulting from the fraud, whether it was foreseeable or not.
All direct loss,
Well,
even unexpected stuff.
Yes. Doyle v. Olby, Ironmongers Ltd. confirmed this. It's a wider scope than usual contract damages. It can even include things like lost opportunity cost profits you missed out on because you were tied up in the fraudulent deal, as shown in East v. Moore.
Yeah.
It's quite powerful.
What's next? Negligent misrepresentation. Where does that fit?
This is kind of the middle ground. It's a false statement made by someone who didn't have reasonable grounds for believing it was true. They weren't deliberately lying. Maybe they were just careless.
So careless rather than dishonest. How do you claim for that?
2 main ways. First, under common law, based on the Headley-Byrne v. Heller principle. This usually requires a special relationship where one party has expertise and knows the other is relying on them. Think Esso Petroleum v. Martin, again, the petrol forecast.
Right.
But the much more common and, frankly, powerful way is under Section 2.1 of the Misrepresentation Act 1967.
Section 2.1. Why is that so powerful?
Because it flips the burden of proof. Once you show there was a misrepresentation that induced you, the person who made the statement is liable for damages unless they can prove they had reasonable grounds to believe it and did believe it up until the contract was made.
Wow, so they have to prove they weren't negligent.
Exactly. And that can be really hard to do, as cases like Howard Marine and Dredge & Co. v. Ogden and Sons show. It makes it much easier for the misled party to win.
And the remedies for negligent misrepresentation under Section 2.1.
Again, rescission and damages. And importantly, the courts have said, like in Roy Scott Trust Ltd. v. Rogerson, that damages under Section 2.1 are assessed on the same basis as fraud damages.
So that broad, all direct consequences rule again.
Yes. Even though it's negligence, not fraud, the damages can be just as extensive. It's a bit controversial, but that's the position. It makes Section 2.1 a very attractive option.
Okay, finally. Wholly innocent misrepresentation. This sounds like an honest mistake.
That's exactly it. A false statement made by someone who genuinely and reasonably believed it was true. They had grounds for their belief, but it just turned out to be wrong, no fault involved.
So the law treats this more leniently. What are the remedies?
The primary remedy used to be just rescission, sometimes with an indemnity.
An indemnity, what's that?
It's a payment to cover expenses you had to incur simply by following the contract terms. Think rent or required repairs on a property you leased based on an innocent misrepresentation, like in Whittington v. Sealhane. It's not damages for loss of profit, just reimbursement for obligations taken on.
Okay, so rescission and maybe indemnity. Anything else?
Yes. Under Section 2.2 of the Misrepresentation Act, the court now has discretion. It can decide not to allow rescission and instead award damages in lieu of rescission.
Damages instead of canceling the contract.
Right. If the court thinks rescission would be too drastic, maybe unfair to the other party, it can say, okay, the contract stands, but here's some money to compensate for the misrepresentation. It considers the nature of the misrepresentation, the loss it caused, and the loss rescission would cause the other party. It's a balancing act.
Right. Let's dig into those remedies a bit more. Rescission setting the contract aside, how does that actually work?
Well, the goal is restitutio in integrum, to put both parties back in the position they were in before the contract was ever made, as if it never happened.
Undoing the deal.
Exactly. Usually, the innocent party does this by giving notice to the other side. Sometimes, if you can't find them, taking reasonable steps to show you reject the contract can work, like telling the police if goods were obtained by fraud, as in Car and Universal Finance v. Caldwell.
But it's not always possible to just undo everything, is it? Can you lose the right to rescind?
Oh, absolutely. Rescission is an equitable remedy, meaning it's flexible and based on fairness. You can lose the right in several ways. 4 main bars to rescission.
Okay, what are they?
First, affirmation. If you find out about the misrepresentation, know you have the right to rescind, but then you carry on with the contract anyway.
Like you accept it.
Yes, you either explicitly say you'll continue, or you act in a way that shows you intend to. Long v. Lloyd is an example. The buyer kept using a faulty lorry after discovering problems. That was affirmation. But crucially, you have to know you have the right to rescind, not just know the facts of the misrepresentation, as Payman v. Lanjani clarified.
Okay, so affirmation is 1 bar. What else?
Second, lapse of time. If you wait too long before trying to rescind, you can lose the right. What's too long depends. For fraud, time usually runs from when you discovered the fraud, or reasonably could have.
Right.
But for non-fraudulent misrepresentation, negligent or innocent time typically runs from the date of the contract itself, not discovery. Leaf v. International Galleries shows this. Waiting 5 years to complain about a painting wrongly described as a constable was too long.
Ouch. Okay, 3rd bar.
Third, impossibility of restitution. If you can't substantially put things back the way they were, rescission isn't possible.
So if the subject matter has changed drastically.
Exactly. Like in Vidges v. Pike, trying to rescind a mine lease after loads of minerals had been dug out, you can't put the minerals back. But note, it doesn't have to be perfect restoration. Substantial restoration might be enough. In Armstrong v. Jackson, shares could still be returned even though their value had dropped significantly.
Okay, substantial, not perfect. And the last bar.
Fourth, third-party rights. If an innocent third party acquires rights in the property before you rescind, for example, they buy the goods in good faith, then you usually lose the right to get the property back.
Ah, like the scenario in Phillips v. Brooks.
Precisely. A rogue gets jewelry by misrepresentation, then sells it to an innocent pawnbroker before the original seller rescinds. The original seller couldn't get the jewelry back from the pawnbroker. The innocent third party is protected.
So with all these potential pitfalls and serious consequences, can people just put a clause in the contract saying, we're not liable for any misrepresentations? Can you contract out of this?
That's a really important practical point. Can you just use an exclusion clause? The answer is, it's restricted.
Restricted how?
Section 3 of the Misrepresentation Act, 1967, as amended by the Unfair Contract Terms Act, 1977, deals with this directly. Any contract term trying to exclude or limit liability for misrepresentation or restrict the remedies available is only valid if it satisfies the requirement of reasonableness.
Reasonableness. Okay, what does that mean in practice?
It means the term has to be fair and reasonable to have included, considering everything the parties knew or should have known when the contract was made. And crucially, the burden of proving it is reasonable falls on the person trying to rely on the clause.
So they have to justify it.
They do. It's a key safeguard to stop stronger parties just forcing weaker parties to accept clauses that unfairly strip away their protection against being misled. Fairness is the touchstone.
Wow. Okay, that was a really thorough exploration. Misrepresentation is clearly way more complex than just telling a fib. We've gone from what counts as a false statement fact versus opinion, silence, actions, all the way through to materiality, reliance, the 3 types, and those crucial remedies like rescission and damages.
Absolutely. And understanding these principles really does empower you when you're dealing with agreements. It highlights how much context matters, not just what's said, but how it's said and who's saying it.
So the key takeaway for you, the listener, when you're looking at signing something, remember these nuances. Think about what you were told or maybe what wasn't said that led you to agree. That's where your potential rights lie.
Definitely. And maybe a final thought to leave you with. In our world today, with so much information flying around, online reviews, social media claims, even AI-generated content, how do these long-standing principles of misrepresentation apply?
That's interesting.
The core idea of being induced into a contract by a false statement is still central. But the way those statements are made and how we assess things like reliance or reasonable belief in a digital age, well, that's constantly evolving. It really underlines the need for critical thinking in every single interaction, doesn't it?